Okay, good morning, everyone. This is the POR Working Group meeting for Wednesday, December 15th, 2021. Our subject today is going through the results of the polls so that we can get some direction on the future of this report going out. This is open for discussion. Again, these polling results do not mean that anybody is set on their final support for any report or any sections of the report coming out. This just gauges the support so that we have direction on where that report is going. So, is there anything to start out first, Olivia?
No,
Okay.
thank you.
Okay. Our chairs, Angie. Okay. Sheriff Heck. Anything? Stacy.
Yeah, I'll just, excuse me, just add on to what I mentioned in the email responding to the poll that was sent out, which is to acknowledge that there's some other issues that were important to the group, or that at least some members had expressed concern about, that we address. And I just want to make sure that we have a chance, perhaps after we're done discussing the poll and what the report might be looking like, we can come back to those issues, which was collateral consequences and residency restrictions.
Okay. So what we can do at this point is just go to the poll results and start our discussion at that point. Actually, probably good to look at our meeting schedule just so you get an idea of how we're going to approach the final report here. Again, this is subject to revision as you as a group or as the chairs wish to change. But the idea is that we have our meeting today to go over this approach, a rough draft available next Wednesday. Some discussion in those areas can go on. And then over the holiday break, you can spend some time reviewing if you'd like, or you can start up right after the first of the year, looking at that, thinking of any revisions, any discussion areas for our next meeting on January 5th. We'll have time to do revisions so that there is something more of a final draft report on January 12th. And then really looking at trying to finalize this report on January 19th, with hopefully just minor revisions over the next week to button it up and finish it off on January 26th so it can be submitted to the legislature. Any questions on that calendar? Suggestions? Okay. Let's move to the first question on the poll, and that was restart of registration, the status quo. Looked like there was pretty strong support to not stick with the status quo on restarting of the 10-year registration period.
Mark, could you put the Are you gonna share screen? Or could
Oh,
you?
Sorry.
Because I don't know, I don't know that other people have.
Oh, okay.
Oh, okay.
I thought, sorry about that. Thought I was supporting that already. Let me just get to that. Okay. Do you see that now?
Yep.
Questions? Anything on that? Looks like pretty strong support to not leave as is. Additional comment here.
Yeah, that's one thing I was gonna say is, and this is really more to the second and third questions, but there's about 20% that say they don't want the status quo, but that don't support kind of the language that we've looked at. I'd be interested to know what, like what they're thinking as far as changing the status quo, if not the way that we talked about. Does that make sense?
Yep. And we'll go over that in the next questions. But yeah, this question's a pretty generic one, has no specifics on it. So that's why this comment from BCA. And then here's the first question on that restart on a change poll number 2. Essentially, it would remove most misdemeanors, not all misdemeanors, because there are possibilities that some of those crimes fall under the list of crimes against the person.
Or registration offenses.
Well, keep in mind that registration offenses will always restart registration. So
Right.
So any questions on this particular issue? So it looks like this isn't the solution for everyone. Okay, Sheriff Heck, you can unmute.
Thank you. Just one quick clarification for my own purposes. The current language talks about resulting in incarceration as being kind of the key to making a crime a restart. Is that pre-sentence or post-sentence? So if somebody gets arrested and brought to jail prior to conviction, does that count as a day of incarceration, or does it have to be after they're sentenced?
Sheriff,
It
I
has
can
to be
answer
part of the
that question. Oh, sorry, Angie. I was going to say, Sheriff, that in 2014, any period of incarceration, credit for time served counts. Anything before August 1st of 2014, the time had to be served subsequent to the conviction. But as it stands now, it's credit for time served also counts.
But it still has to be part of the sentence. It can't just be, if they didn't receive that as part of the sentence, as credit for time served or a sentence, then it doesn't count.
Right.
Right. So say somebody got picked up for driving after revocation and the officer brought them to jail. Their sentence included no jail time. That would not qualify as a restart then.
Correct.
Yeah, under the status quo also.
Right.
Yep.
So I guess my only comment to this question then is people might have the mistaken idea that if I get arrested for a traffic offense, that's gonna automatically mean that I gonna have a restart, when in actuality, the people that get, in my experience, people that actually get incarceration for these low-level offenses is relatively few, or someone that has many, many priors.
So important to keep in mind, this is the status quo. The current is that it has to be part of your sentence. So, anything additional on that? Okay. Representative O'Neill.
So this is a little broad in the description. Does this include, so if you've got a drug or alcohol offense that lands in the misdemeanor category, is that in or out in this question?
I would assume that's out. Anybody else who was involved in this?
Yeah, I would think it would be out because if it's a
I do too.
misdemeanor.
Yeah, if it's a misdemeanor, it's out.
And I think, well, I'll only speak for myself, but I'm one of the no's because of the nexus between drug and alcohol use and addiction and committing crimes. It makes them much more likely that they're going to commit another crime if they're actively involved in their addiction and not sober. And so if you're talking about making sure that we're keeping the public safe, those absolutely need to be included in my book anyway. And I'm guessing maybe some of the other, there are 8 that said no, maybe that's what it's about. I'm not really sure, but that's why I voted no on this one, because it did, from my reading of this, it didn't include drug and alcohol misdemeanors.
Right. And I think there's agreement that you're correct in that. Yep. So anything else on this?
Stacy has her hand up.
Okay. Yep. Stacy.
Yeah, just a follow-up to Representative O'Neill's comment. I guess what I would say is understanding more about Brian's research or the research that he's shared with us about recidivism rates. I think this, if the misdemeanor issue, suggesting that if they commit a misdemeanor, they're more likely to commit another crime if they're engaged in their addiction. And I think a conviction and imprisonment for a misdemeanor, let's say traffic, driving under the influence, I think it assumes a lot about what's going on for that person. One instance doesn't mean that they are full into their addiction, living day in and day out in their addiction. It may have been one slip. And it also doesn't mean that they're, necessarily, while the risk of going out to commit another sex offense is somewhat increased, although I think it's still de minimis. It assumes by keeping them on the registry or restarting them, it assumes because you got a DUI on this one time, we now understand you to be more likely to go out and commit a sex offense because of that one moment in time. And I just think it puts a lot onto one conviction.
Okay. Any other comment on this? When we go to the next issue, it'll probably reflect the same feelings because the next one takes even more off. So it's a similar response. Let me just make sure of that. Yeah. It's a little bit of a difference, fewer votes on this one, but still the same breakdown. This would take off most gross misdemeanors and misdemeanors, so that seems to be reflective of the positions here.
I think the reason the numbers are different is because I thought we were supposed to pick between 2 and 3, so I voted on 2 and not 3. Or I guess maybe I should have voted no for 3 then. I don't know.
Representative Moeller.
Thanks. Can I ask for clarification what the BCA's comment was again, that you posted that before 2 and 3? Does that align with either 2 or 3? Or is that a different proposal?
This is a, well, this is a comment about that.
Go ahead.
This was one that was
Mentioning-
previous though. Yeah, there was one that came that you put up before we had number 2, I think.
Oh, okay.
Yes, could the BCA please explain if that aligns with number 2?
Okay, Representative Mueller, I can address it. This is Katie. What we were looking at, it doesn't really align with, we had said, what are we on, Mark, 1 or 2 and 3?
Yeah.
We said no to 2 and we said yes to 3. What we were trying to avoid is the restart of a driving offense, being specifically the driving after revocation, the driving after suspension. I know there was one instance where somebody served jail time in lieu of paying their child support. And so that's where we were looking at it, but not wanting to eliminate just all misdemeanors, as some of these get pled down. We see it all the time. And I think we, all of us that are in the field can say we see some of the felonies get dropped down to a misdemeanor, gross misdemeanors being pled down to a misdemeanor. And so still catching those other offenses, just eliminating that driving after suspension. Those you know, the driving violations, if you will, was where we were going with it.
And non-alcohol related driving offenses?
I guess, I don't know that we got into that part of it, but yes, I mean, maybe the DWI stay in there. I'm not, you know, I don't know necessarily if that's where we want to go necessarily with the driving offenses, but for sure, we talked about the suspension and the revocation. As it doesn't really, you know, some of the offenders committed offenses while under the influence of alcohol and drugs. So I don't, you know, that's something to be discussed whether or not the DWI stays in or not. But for sure, those suspensions and revocations.
Thank you for that clarification. That's helpful.
Yep, you're welcome.
Yeah. And that could have been perhaps another question there. Would you support the restart except for certain denoted offenses? And I think, Angie, you had mentioned that in earlier discussion.
Yeah, I mean, it seems like there's generally support for changing from the status quo in some way, but it's a matter of which offenses are included for the restart ultimately.
Yep. So I think the results that sort of reflects that the getting rid of all most misdemeanors, getting rid of most gross misdemeanors doesn't address that. The anticipated limitation on restarts that the first poll question indicated. So. Okay. Any more discussion on this? Okay. And this was one of those additional comments that's related. So next question. Support for the status quo on mandatory minimums. Seem to be,
Mark, can you go back one slide, please?
yes.
Where, whose comment is this? Is
I-
this the one from the BCA? Because
Yes.
you failed to include the last sentence that the BCA would support the removal of certain gross misdemeanors and traffic offenses from the list of crimes that trigger the restart of registration. We had a,
Oh,
Okay.
that was in here earlier.
okay, but that was related to question 3. I just want to make it clear that those two pieces go together in relation to, we responded to
Yeah.
question 3 on that. Just so the team know, but everybody else doesn't know that. You might know it from the response. Thank you.
Yeah, that, the 3 grouped there is these comments. I think we just had that discussion about certain gross misdemeanors and traffic offenses, so. Okay. So now the mandatory minimum, the status quo. Seems to be strong support for changing that. The next and if you, the comment from the BCA on this, did you want to make any further comment on it? But I think it goes to the language that was actually presented, the draft. And this would be the modifying that mandatory minimum. And included in the resource material was actual draft language. Any additional or further discussion on this? Seems to have strong support. Again,
So we just want to be clear that the language presented in the reference document specific to that question. We're seeing that these comments are a little bit different than what we put in our comments in the document. And so just know that that's in relation to the comment, the language associated with the actual question itself.
yes. I'm not sure if there's confusion there that the actual statutory language revision was provided, which essentially says that keep felony level for repeat of conviction. I don't know, is there any disagreement or dispute on that? So the next issue goes into the false imprisonment. Again, there seemed to be strong support for something other than the status quo, where false imprisonment would be for conviction or another offense arising out of the same set of circumstance. So when it's presented as that change to convictions only, remove same set of circumstances, Seems to be strong support for that. Any additional comments on that? Anybody opposed? Okay, Representative O'Neill.
Thank you. And maybe you were just going to say this. I was just hoping that somebody on the no side would explain their no. This is something we did talk about a lot, and kind of how false imprisonment is, I'm just going to use the word misused by prosecutors to try to get something else because of the threat of the POR registration. And so I'm just wondering, did I miss something? What are the no's about on this one? If someone would be so brave as to say.
Any comments on that? Seeing none, should I move on? Okay. Okay, now into the next, a new area. And seems to be the same issue with juvenile registration. Do you favor the status quo? Maintain the registration as it is. Seems to be strong support for a change. But the devil is in the details. Next thing is the idea of removing juveniles from the registry. Which means the only juveniles would be those certified as an adult. Closer split on this. Any further discussion on it? Seeing none, move to the next question. Oh, let's just put this comment in here.
I think our concern, whether we had talked about with the judge making determinations, was kind of the way it would be treated differently by different judges and kids with different attorneys, and kind of disparate impact with that kind of thing. When we were talking about this language.
Renee.
I would definitely agree with that. I could envision some judge shopping going on for sentencings then perhaps. So I see that. I know that it's done within the system, so I would be concerned about judges determining that also.
And Representative Moeller.
And I could be wrong about this, but I feel like we had discussions early on when we talked about judges deciding these things as part of sentencing, that it changes sort of how registration is treated, that it's not necessarily part of sentencing, and putting it into sentencing could create a whole host of other concerns, but I could be wrong about that. And I see Superintendent Evans is here and raised his hands. Maybe he has comments on that too.
So unless there's objection, I'll allow Superintendent Evans to respond.
Yeah, thanks, Mark, and thanks for letting me join the group here today. And I just wanted to provide a little context. And I know you've had discussions, and I don't want to interject myself into those discussions. I think I just want to provide a little bit of context and agree that, you know, that's a concern, and I think it's a valid concern. I think that the process for us, that the discussion we had about juveniles, is that it is a different court process, and that the goal of the, you know, juvenile process is different than our adult system. And so in this situation, and I agree there would need to be specific discussions about how that would be done, is that it was difficult for us to determine a true on-off switch for all juveniles when we were kind of thinking through some of what we see. And so we thought that a judge in the adjudication process in the juvenile court would be able to take into a number of different factors that normally wouldn't be contemplated for this with adult. In other words, the potential concern for safety, the developmental factors that may go into this, a whole host of different things that are unique to juvenile court that are not in the adult system. So it's certainly not a hard and fast, position that we would take on this issue. We were just trying to make a determination how to account for some of the unique aspects of juveniles that you all have all debated, that people have kept me up to speed on, that I think are very valid to consider. And we certainly agree that not all juveniles should be on the registry.
Any other comments in that area? We do have another
Yeah,
poll question.
Mark, if I can just comment on what Representative Moeller was saying too, and Superintendent Evans was not able, obviously, to make all the sub meetings, but yeah, that was one of the concerns, is it being, in addition to the potential for disparate impact, is that registration is a collateral consequence, and kind of getting it too close into the sentencing or disposition part of criminal cases, I think is going to create issues with that part of it being a collateral consequence. And I know, and this is something also that Superintendent Evans, not sure if you're aware, but we, at one point, the group looked at, kind of limiting it to EJJ and adult prosecution, but then we were looking at the language for that. There were all kinds of issues with out-of-state offenders and federal offenders in that kind of situation. So we kicked around kind of a lot of things and sort of landed on making some kind of change that's clear to determine on juveniles, but whether that's by age or by some kind of listed offenses or something like that, we haven't really been able to settle on.
So here's another variation on that, which is interesting because this doesn't seem to satisfy people either. So Sheriff Peck.
So I guess as to both of these issues, I'll kind of repeat my overarching concern is to the majority who favor one of these two, how do we sort out those juveniles who are going to grow into the offenders that need to be on this list? And if we don't have an answer to that, are we comfortable saying, well, I guess if we find you as a juvenile, then we're just not going to have you in the system?
Janine.
Good question, Sheriff. I don't know the answer to that 100%. I would just offer up that when a juvenile comes into the system, I think that if we over rely on the registry to do everything, we're discounting and diminishing the impact of other systems that surround juveniles when they get into the system. So in my opinion, the registry is relying on a behavior to create criteria for inclusion. If that behavior includes someone into other systems where they can dig deeper with therapy, with supervision, with in-home services to see what it is that has been the motivator in there, that would flush out the differentiation between those we really need to keep an eye on, that this is the start of a pattern or a trajectory versus one that it is an incident, heinous as it may be, but not the type of individual that we're looking for to be on this registry. So I would say that the good news about juveniles who end up in the system is that there's a lot of eyes on them and not just a registry. So I think that we need to take into account considering the professionals that also would be on the same page as us with the mission of no more victims.
Patty,
I am going to reiterate a statement I made early on about the military has decided not to allow any of their youth to be on an adult registry because the military wouldn't take a 14-year-old to be in the military. They recognize that juveniles are far different than adults. And I think that the registration is for adults. It was created for adults. And I think that juveniles respond to the things Janine was talking about, all the resources for change, and putting them on an adult registry does not prevent them from becoming the troublemaker that Sheriff Heck is talking about. It doesn't, as a matter of fact, it has a negative effect. The goal is to have no more victims, and getting these kids the right services and to change their behavior is a far better option than putting them on an adult registry. Thanks.
Sheriff Heck.
Okay, to Janine, would you be suggesting then that there maybe be a system where juveniles, where there would be some type of professional that could make a decision subsequent to their conviction as to whether or not there's someone who is likely to exercise this in the future and therefore should be included on the registry? Or I mean, is that something that might be more workable as a solution?
The trick is, it's a great idea. The trick is that we don't have the science for that with juveniles for the very reason that Patty's talking about, because the paint is still not dry on an individual. And to do actuarial tools on that, you need to have someone who has a pattern. So I don't know that doing it, what you could do is similar to what we had talked about with Hennepin County, that when they do stay of adjudication, or have someone, they have someone on their radar, and then they keep an eye on them, give them opportunities to change, understand the individual more. You're going to need that kind of time with eyes on that person. And then you can make a decision perhaps at the end of that. But I feel like when the demarcation is the behavior itself, and that's just how our system operates, that's premature there to make some pretty strong decisions that could negatively impact a person. And that would waste resources because you're going to be having people on there that you don't need to be tracking. And so it's different with juveniles, Sheriff. It just is. We can do that more effectively and predictably with adults, with the science and the tools that we have. But this field just doesn't have them for juveniles in the same way, because for the very reasons we're talking about, they aren't solidified yet physiologically.
Hey, Mark, sorry to interrupt. Apparently Representative O'Neill can't get back in. Can somebody help her get in?
Okay. She can't get in. So she's not in our waiting room. If she wants to use that link, that I sent this morning, which is the same one, just a duplicate. I guess I'm not sure what the issue is, since she's not in our meeting at this point.
Okay, I was just asked to let you know that, so I don't know.
Is that from an email or?
From a text.
Representative Moeller.
Yeah, I have been communicating with her, and she said she was blocked from getting back in, but I'm just texting her now and telling her to use the link from this morning. So I will let you know if I have any more technical information about that.
Okay. Yeah, I'm not sure. I don't think anybody else is having any issues, so.
She's having internet connection issues. Maybe I'll suggest she calls in, goes in maybe with a cell phone.
Yeah.
All right,
She can
Okay.
do that too. Okay.
sounds good.
Okay, anything else on this? I think the same kind of question is those voting no, is it the same on both questions about removing juveniles? It doesn't look like much of a change. Okay, we can move on. And this was an additional comment, and I think actually Representative Neil O'Neill has brought this up earlier. And that is supporting the extension of the period of the stay for juveniles to either 18 months or 24 months. Again, I'm assuming that that is the reference. Okay. And here's the question: allowing a petition for relief from registration seems to have strong support. But once again, the devil is in the details here. And here's comments from the BCA.
Olivia and Katie, when you say supports an off-ramp process for lifetime registrants, do you mean lifetime registrants only?
Yes, Angie.
Right. From that language that was provided, that draft, because it was a 5-year, that would cover those with 10 years, the possibility. Any other comments on this? And this was really focusing down on a couple really detailed issues. And that is, if there was a 5-member review panel, would it require a unanimous vote? Majority say no. That's kind of interesting, the next two questions. I think this was maybe a little too complicated and too detailed. Because the next one said, should it be a 4-5 vote? There's a split. And then should it be a majority vote? There's a split.
One thing that I was thinking about with the unanimous vote, and I realized that something Representative O'Neill thought would maybe be needed to get this anywhere anyway. But one thing I was concerned about with that, or I thought about with that, which maybe this came up in a meeting too, is does that potentially give one person on the panel too much power? You know, I guess that's one of the concerns with unanimous vote is that maybe one person for maybe not a reason that's supported by the other four, you know, thinks somebody shouldn't get off. So I think that's just one concern with unanimous votes in general, but just thought I would raise that.
Yeah, and you know, and this is understandable that this may have gotten a little too detailed to ask the question, but we do have people, 14 who said, no, it shouldn't be unanimous. But when the other two options were given, either 4 out of 5 or 3 out of 5, we didn't have 14 people supporting that. So it's kind of a mixed answer. Representative Moeller.
Yeah, I wonder if people thought they had to like support one or the other. You know, I voted yes for both of those because I didn't think it needed to be unanimous, but like either one of those would have been okay with me. But if other people might have thought about it differently and thought they had to vote yes for, you know, one of those options. I was just curious again to go back to the BCA's comment on this registration. And I can't remember if we had details on this. The federal requirements, do they require a certain period of registration?
They require a period of registration based on that tiering. And off the top of my head, I can't remember if it's a 10-year or a 15-year, but it all correlates back with the tiering, which then essentially looks at the corresponding certain offenses that would relate to that tier.
And is part of your concern with your comment here and what you would and wouldn't support based on those federal requirements? Or is it,
No.
is your comment unrelated? Your comment's unrelated to the federal requirement?
Correct.
Okay, thank you.
Renee.
Yes, I would just like to comment that there's a process in place, the ECRC, that is successful, and that is something that is available to all offenders or clients. So my concern with only lifetime is it doesn't provide the opportunity for others that are required to register to have that process in place for them too. It seems to create a disparity. And that would be my comment. I definitely would support those that are on 10 years to also have that opportunity to offer it and go through that process.
So back to that issue. So any additional questions, comments on the off-ramp, or as termed here, actually, relief process? I think the language was changed in the poll to stay away from the idea of an off-ramp. Patty.
Maybe that's something that we could just put out as a follow-up. What would it take? You know, 73/4 of us agreed that there should be something. What would it take? And just kind of throw that out so that we hear what are the constraints for the follow-up to questions. Because I think there's agreement that we need something. So what we just need the follow-up. What would it take?
Yeah, so there is that language out there, but maybe even more detail needed in a future draft, which probably needs to come pretty quickly. Next question was change the term predatory offender. Renee.
I would ask if anyone would like to comment who voted no. What were your reasons for voting no? I think we're doing a shift with probation reform, and I know the DOC is coming along with not referring to our clients as offenders. And many of the clients that are on registration are not predatory in nature. So I'm just curious if anybody would be willing to comment about that.
We do have the one comment from the BCA.
So Renee, we were a no on that with that comment added in.
So Sheriff Heck,
I remember going back and forth on this when I answered the question, and I think I voted no simply because I saw it as not as substantive as some of the other issues we're tackling here. I'm not necessarily opposed, even though I voted no to changing the name of the registry, as long as it serves the purpose. I really don't have a strong opinion on what it's called, but I just thought it was not a burning issue.
so that's useful discussion to see whether they're soft no's or soft yeses or strong no's or strong yeses. Stacy.
Excuse me. I just wanted to hear from the BCA as to why they don't want to change the word predatory. If they're willing to say so publicly.
The
So
comment
this is our
up here.
comment below, Stacy. That was the piece that we added. So we said no, but as we wouldn't oppose changing it as long as the descriptive, yeah. So we've got that in there.
Okay, thank you. Thanks
You're
for
welcome.
the clarification.
Yep.
Janine.
To Sheriff Heck's comment, I guess I'd raise a question about maybe to the representatives here. Would having this in as an issue or a point in the report detract by optics some of the other recommendations? Because it feels to me also, I would like to change the name, but I also don't want to raise that as a issue here if it looks like the overall message of the report is then either soft on crime or we are leaning to a certain direction or another, that the other points that are more complicated and sophisticated won't be taken as seriously. Maybe that's just my wonderment about optics. I'm curious what the representatives think about that, knowing their body where this will be looking at the report.
Patty.
Yeah, I'm curious about that as well. However, it was created as a sex offender registry, and as Janine said, many of these people, especially if you're talking about juveniles, most of their victims are not predatory in nature. They're situational, and they have fewer victims than the stranger abductor kind of sex offender. And I just think it was created as a sex offender registry, and it's grown. It was part of the Adam Walsh Act where they changed the language, and I've been opposed of that language. It's also very much more. It creates community fear, and it doesn't help. It doesn't help. That's my opinion.
Angie.
I voted no, kind of for similar reasons to Troy, but also because of the whole issue with when we were discussing this. Basically, we hadn't really come up with a great alternative, and kind of the discussion about people don't like to be called sex offenders and they don't like to be called predatory offenders, so kind of like what the BCA said, is there a good, I don't think we would necessarily be opposed to changing it, but a good descriptive alternative, because you do get people who would prefer to be on the predatory offender registry than the sex offender registry, and vice versa. So that's kind of where we were coming from, but also some of the substantive changes seemed like they would be more helpful.
Representative Moeller.
Thanks. Yeah, to answer the question about would it detract from the other more substantive work that we're doing, I think the answer to that is no. And I look at the Criminal Sexual Conduct Working Group report. This could just be one of other things that was discussed and where members had disagreement on. And I think it would be useful to say, you know, all of those things. And then these are some of the concerns, but also these are some of the suggested title changes, and leave it at that. And that's certainly something that we can grapple with when we're drafting legislation. You know, just thinking about it now and talking about if it said sex offense registry versus offender. So you're not naming the person, you're naming the act. But then to Angie's point, there might be some people who still don't like that label and would prefer the predatory offender. But I don't think it would hurt to put this in the report and give the different alternatives. I mean, no one's saying we're going to call it the unicorn and rainbow registry, right? So I think just putting it in, putting those alternatives, and then, you know, as we're working on the legislation, we can talk about it.
Okay. Chief Peskin. Are you able to unmute?
Yeah. Yeah, Mark, thanks. Yeah, much in the way of the Chair Keck looked at it when I was answering the question. I didn't think it was substantive enough to spend a lot of time thinking about what perhaps that might sound like or what that title might be, but certainly not opposed to a name change that is fitting, that will represent the registry. But more, that was the reason for my no vote on that.
Okay, I think this discussion was very useful in identifying that those no's are not very strong no's as long as there's an alternative way of reference. So Representative O'Neill, welcome back.
Oh my goodness, I am up in Thief River Falls and it was a nightmare to try to get connected. So, all right, I'm going to disagree with my wonderful colleague who I mostly agree with on the vast majority of things, but I'm just going to tell you from the Republican side of the aisle, we could get hung up real quickly on a name change and make no other change. We could spend hours debating what the name should be. I just think it's kind of an unimportant discussion when you want to do things like off ramps, changing the age of juveniles that can be on it, some of these very substantial things, and the name just isn't very relevant, and it could get really hung up in long conversations, particularly in the Senate where they like to pontificate a lot. And I just had a senator leave who helped me get back online, and I just don't think it's really a valuable discussion if it's going to suck up all the air in the room.
So there's a strong no. Any other comments on this? Okay. Oh, Stacy?
And this would probably be one of the few points that Representative O'Neill and I agree on. I too feel like the name change is, of all the things that we're working on, it's, for me, substantively, it feels pretty low on the list. I hear the concerns of people who have raised this as an issue. I think it's complicated, like all the issues that we're dealing with, but the substantive legal effect on registrants by a name change or not a name change is, I don't see a significant substantive impact. So I voted no, and very much for the same reasons that we have such meaty complex topics to work through, I wouldn't want to distract from the agenda. And I don't know that there's going to be a resolution on the name because there's sex offenses and then there's the handful of predatory, and watering it down, which I think it would sort of be. I don't think anyone at the legislature has any, I don't think that there's making registrants feel better about their registration status is going to be a legislative priority, is what I'm trying to say. I could be wrong. I'm not a legislator, so I don't know. I'm just guessing that in terms of all the priorities, changing the name so that the registrants feel like, or that maybe the impact is less significant. I don't see that as ever being a legislative priority.
Any other comment? Okay, next. Yeah. Here's a pretty generic question. Do you want more data? Any comments on this issue? Any comments from the no? Okay, here's the one unanimous thing. This was one of those issues that was brought up a number of times, but not a lot of time to go into detail on this. Okay, then there were additional issues in the comments. First one. And Angie.
Yeah, I'm not sure who made this comment, obviously, but this would be a little bit of a nightmare. BCA relies on courts and it relies on probation officers and it relies on the DOC and it relies on all kinds of people to find out if somebody potentially should be on the registry. So to have a statute of limitations, I know we didn't really talk about this, so it's probably a minor issue anyway, but I just wanted to let whoever know that from a practical standpoint, it would be a big problem to limit it to 90 days after sentencing because they don't have a way to control other people and whether that information is getting to them. Sometimes attorneys, probation officers, judges think the registry does apply or the registration statute doesn't apply, so they don't get the information of the BCA when in fact it does apply. So there are all kinds of logistical reasons that there really can't be statute of limitations, and our courts have upheld that when registration has had to start later. They certainly make every effort to get people registered as soon as possible, and they do it as soon as they get that information that it applies to them. But that can't happen always within 90 days after sentencing. And in fact, I think many times it can't happen or doesn't happen.
Okay. Anything else on that comment? Okay. Next comment. Anyway, this issue has been brought up in past discussions. Angie, did you have a comment or not?
Sorry about this. So this one, I think this kind of our second to last question is this kind of the subcategory of that, getting more information on the efficacy of the registry. I think that any kind of evaluation of what law enforcement agencies are doing would require a survey of every law enforcement agency in the state to really get a good idea of what's happening with these issues. I think that's something Representative O'Neill talked about that they did with like the rape kits. I don't think you can just pick 10 or 20 because I think, some agencies might use it a lot and some might not use it at all as far as the crimes go. So.
Sheriff Heck?
I'd second what Angie was saying about the extent of the data gathering you're going to have to do. I'm not opposed to doing it. I think it'd be good information to have. My concern is that we're talking about a very small number of cases that this would apply to. So it's going to require, I think, gathering a lot of data to really get a good picture of how often this is used for its intended purpose to solve those cases where you have an unknown suspect, which are very rare.
Stacy.
So this is my comment. What I don't want to have happen, the reason I suggested 10 to 20, and they could be, they could be different sized, some larger ones, some smaller ones. But it's just to get a sample. I think that if we sample all the counties or all law enforcement agencies, we're talking about, sorry, I'm having technical issues here with sound. I'm afraid that we're going to have a deluge of data that requires a lot of analysis, but if we can just sample to get a sense, and then maybe after the sample, then you take it the next level and do a deeper dive, but to get some sort of understanding of how a variety of different sized law enforcement agencies in different locations throughout the state, you'd have both metro and rural, to see how it's being used would at least give you a flavor. And it's a starting point and wouldn't cost as much money.
Sheriff Heck.
To Stacy's point, I'm pretty confident that if the legislature appropriated some funding to do a professional in-depth study of this, and you describe to the professionals that do this, the parameters that we're looking at and the kind of numbers they're trying to capture, that they'd be able to come up with a method to accurately find the data. That would likely be less than surveying everybody. I think that they've got ways to do that.
Did that answer your question, Representative Moeller, or comment? Okay. Any other comments on this? Oops. And that's it for the comments, unless I missed anything. And then Stacy, I think you had additional issues that you wanted to make comment on.
Yeah, I just want to make sure that we don't forget about, well, Angie's work on the compiling the statutory connections to the registry in terms of collateral consequences, like the prohibition on working in the horse racing industry. And at least having, that's just an example, but having a discussion about, what those are and, whether they warrant modification, and then the residency restrictions that was raised at the very beginning and kind of withered on the vine. I'm not sure why, but I'm trying to resurrect it a little bit just to make sure that you know, some people might believe that a failure, you know, this group's failure to address those two really big issues, which really impact both the registrant's family and also victims, that we need to look at it and at least come up with some acknowledgement or something. I feel like we need something. I'm not sure what we can do though with the time that we have.
I think this has been a good exercise in kind of focusing some of these issues. Has been useful too. Let me see, Sheriff Eck.
So Stacy, I guess my question would be, an acceptable outcome of this would be a mention in the report about the issues, or are you looking to hopefully have enough dialogue to generate some kind of proposal?
Yeah, so speaking personally for me, I don't think that I would have the capacity between now and January 19th to work out proposals or to schedule the extra time or, you know, do that. Just from a time perspective, it's prohibitive for me personally. I think a really good scenario would be to address in the report that these two things came up and they need to be worked on. We need to further work on it. We're not done. 4 months wasn't enough. We tackled some big issues. We had a lot of conversations, but there's so much to this registry that we didn't get to touch on, and those are two of the big ones. Now, if people don't agree that those are two of the big ones, and you know, we can have a conversation about that. We can decide like, no, it's not, they shouldn't be in the report, or you know what, I'm obviously, this is just my personal thoughts.
Janine.
Thanks. I'm wondering if there's a way to, no doubt we can't get everything done that we're wanting to get done in the time frame, and asking for more time or part 2 or part 4 to this process might be a good idea. I'm wondering about, there was that document along the way of a summary of the unintended consequences or collateral consequences of someone being on the registry. And maybe if we just frame that, like I made a comment, I feel like a while back about in the language somewhere in the report of saying, so much of this depends on what the intention of this entity, of what this is. What was the intention of this? Was it for law enforcement? Was it for monitoring people? Was it whatever that's, and not that we have to have an answer to that, but to give that as a framework for the reader. And then maybe another part of that framework is, by the way, here's this registry. This was the original intention. This is how many people are on it. And here's a list of the consequences of folks who are on the registry. You know what I mean? And then that can set the stage for an ask at the end to clearly, you know, further the extent to which legal entities use this is a remainder area of exploration. Impact or recommendations with regard to unintended consequences, maybe a future direction. You know, something that could, because we do have a lot of information. We may not have final recommendations on anything, but providing that to the readers might be helpful.
Patty.
In answer to Stacy's question, I think it would be good to remind people of the study that was done by the Department of Correction years ago, the retroactive study on how registration would have had zero impact on the cases that they reviewed. I mean, I'm sorry, that zoning restriction. There was a whole study done by the Department of Corrections, and I think that allowing that statement to be included makes a statement without having to do a whole bunch more work. People need to be reminded that we have looked at this in the past.
Okay, Janine, did you have additional comments? Okay, Brian.
I was just gonna
Let's start.
go ahead, Janine.
No, I was just going to briefly say, I don't know what the format of the report is, but to Patty's point, and maybe Brian was going to say this too, we can certainly do a bibliography of national studies of the impact of registry, just nationally, not to say that Minnesota has to do what others do, but just to give a context again for the reader. Go ahead, Brian. Sorry to interrupt.
Yeah, I was just going to jump on the same kind of issue. I'm actually looking at a research and brief right now from the Robina Institute, University of Minnesota, if people are familiar with that. And it just talks, this would be data that could be included in the report. If they need data, they need to show things that residency restrictions are ineffective. This talks about polling, 30 states have residency restrictions. Despite lack of evidence supporting their effectiveness, research shows individuals convicted of sex offenses are not more likely to reside or seek out victims near public places generally included in the restrictions. Just all of those things we've talked about before. And this is kind of a nice, like I said, research and brief, and data from that could be included in the report to show that it really limits the desistance and decreases stability for people trying to re-enter society in terms of housing, employment, all those things. So that's the opposite effect I think a lot of people envision.
And just to address Janine and Brian on this, that the idea that the information and these issues that have been presented, sort of at broad viewpoints, which is the directive from the legislature, to include in this, not necessarily that there are recommendations on anything, but to make sure that those viewpoints and that information is included in the report. So a bibliography is important as really a research tool. Any other comments? Patty?
I just have a question of the legislators. What are we missing? What else do you need in this report? Because, I just am impressed with how many people dedicated so much time in this very short time period. And I want to make sure that it has the impact that we all, that's why we invested. And is there something else that we need, or some way of presenting it that will be most effective?
Great question. Representative Moeller.
Yeah, I having been in the legislature not as long as Representative O'Neill, I'm hoping she'll chime in here too, but I will tell you that the Senate told me that the CSC working group's report was one of the best reports they have ever seen. And so to follow that as a model, and I think everything here that everybody's been talking about, as far as the background information, the recommendations where there's agreement, disagreement, just some other, perhaps things that were discussed and there's no resolution, following what many of you were on that working group too put together for that report, I think would be helpful in light of those comments that I received from the Senate, that it was the best report that they'd ever seen.
Thank you.
Great pressure.
You can do it.
So outdo it is the goal. Did you have any additional comments, Representative O'Neill?
Yes, thank you. So the difference with the CSC working group is that they were trying to get victims of violence, sexual violence, a lot more justice. We had a Minnesota Supreme Court ruling about mentally incapacitated that really put a lot of pressure on the Senate to move it forward. And we spent a lot more time than we are here, and we had a lot more agreement. So I just want to set expectations that, like I said before, if law enforcement is not in agreement who is actually using this database, and I would include the BCA with that, of course, then the likelihood of it moving forward is very, very slim. So I just want to set expectations that it is similar to the CSC working group, as in we are a working group, but the CSC working group met significantly longer. They had more agreement, and they were trying to get victims of violence justice, where this is the other kind of this is kind of the polar opposite of that. We're talking about making things easier for people that have committed sexual violence. So I really think that probably a helpful report is going to be one asking for good, solid data, because what we've come up against every single turn is that we don't have good numbers, we don't have good data. So at least here in Minnesota, I know we've got some national numbers and things like that, but I'll tell you right now that that's not going to be a compelling argument in the Senate. It just isn't. We need Minnesota specific. So that's kind of where we're at. I can't think of anything else that we need to add into the report. There's just by looking at the survey results, there's not unanimous support for really anything except for we need more data. So I just want to set expectations that this may not go very far in the Senate.
Sheriff Heck.
Thank you. And I will, if this discussion is premature, I'll defer to a better time. But I was going to elaborate more on what Representative O'Neill mentioned regarding what are we going to advance as proposals that are going to come as recommendations from this group. What is going to be the threshold for that to be a proposal? Because there are definitely some that have a majority, perhaps even a plurality, but I would echo the fact that the only one that received unanimous support was the call for more data. So at some point, I believe we need to have a conversation as far as what is going to advance as a recommendation of what is that level of support it's going to take.
Absolutely. And that will possibly even come down to the final type review in January. So, Jim.
I just want to say that I was on the work group for the changes in the criminal sexual conduct statute that Representative O'Neill referred to, and that we agreed, we came to compromise on several issues, and one of the issues of contention on that committee was exactly the issue of predatory offender registration. That if you were going to reform it and bring changes, you had to look at this aspect of it. And there was strong support for that. And if you go back and read the report, it reflects that clearly. I understand Representative O'Neill doesn't think that our recommendations will go far. I think that regardless, I think the legislature has to hear from us and others what people think about this, even if they decide they don't want to go far. So, I appreciate her candor, but I think it's important that people say what they think about this. And I commend everybody. We've put in a lot of work on a small, on a big issue in a small period of time. And I do think we can get out a report. Whatever happens, I suppose, is up to the legislature. But I don't think that should put a pall over everyone's effort in trying to put forward what they believe or think about this registry.
Yeah, and just to reiterate, the directive from the legislature was to get that broad perspective, not necessarily just unanimous or consensus on everything. It doesn't even have to make any recommendations as long as the broad perspectives are being represented. Patty.
I just wanted to be clear to Representative O'Neill. I wasn't sitting in on all these meetings to make it easier for people who commit sexual crimes. I really, my concern is about community safety and how can we build it so that those who've done this before have the best chance of not doing it again. And you know, I really think that how we talk about the problem is of it matters too. So I just wanted to state that I think all of us have visions of building a world without sexual violence. What would that look like? What could that be? And I support law enforcement needing the tools that they every tool that they can get to solve crimes. But I also agree with Stacy's question earlier, is like, is this tool doing what the huge expectations are of it? And I'm not sure that, I think it's changed. And I really respect all of the opinions coming forward to look at it. And I think one of the recommendations clearly is going to be some further funding for the data, but also an analysis of, you know, is this doing what we wanted it to do? Because I think for the general public, there is a perception that if you're on the registry, that's going to stop you from reoffending, and police are going to get you right away and all of that. And there's some other research to show bigger information. So I'm excited that the legislature will have an opportunity to have the big picture and maybe few recommendations this time, but the need for further discussion. Thanks.
Okay. Any other comments? Shall we open it up for any comments from visitors at this time, unless, and I will give the members an opportunity first. Looks like we have one visitor who would like to make a comment. Are we ready for that? Okay. So Bruce Bernhardt.
Can you hear me okay?
Yes.
Thanks, Mark. I'm a registrant. And first off, I just want to thank everybody for all the time and effort they've been putting into this. I've sat in on a lot of the meetings. I've watched the videos, and I felt it was kind of important for at least somebody in the registrant community to be aware of what the group was doing. I've sort of been that person. Quick comment, this may be a little more detailed than appropriate for this particular meeting, but I figured this might be my last shot to make a comment before the report comes out. There's an exhibit called Proposals from Outcomes Subcommittee, which we're familiar with. And one of those proposals, of course, is the registration off-ramp. And this is all pretty preliminary at this point. So I apologize if I'm getting a little too granular here, but there's 5 items that are part of that process. And 2 of them pertain to serving the petition to the appropriate prosecutorial office. The other is allowing the victim to make a statement. And just to make an observation, some of us would not apply to these because in my case, I came from out of state and it's been 30 years and I have no idea where my victim is. So I'm hoping that these particular items don't stand in the way of those of us who would otherwise be eligible to petition. And the only other comment I wanted to make, and this may sound odd coming from a registrant, but I think registration should be reserved only for those on lifetime status. And let me explain why. When I was arrested and convicted of a touching offense 30 years ago, I was a practicing sex addict. Sex addiction, I mean, I was living 2 different lives, as many of us are who are in these situations. And I was in very deep denial at the time. And it took me years of treatment to get past that stage. In my case, 7, 8 years before I was really be able to get past this whole denial phase. And that's not entirely unusual for somebody who engages in long-term addictive behavior like I did. And I think, and I may be wrong, but I think there was some talk about a possible 5-year off-ramp. Personally, I think that's too soon. I think many states, as I've been able to discover, start at 15. California just went with a tiered registry that goes to 20 for tier 2 registrants. And it may not necessarily be that long, but I just think, given my own personal circumstances and what I went through, I wouldn't have been ready at 5 years. It takes a long time. It takes a long time to get the treatment you need, and then to show a steady track record of living an exemplary life offense-free. So again, thanks for giving me the chance to watch these proceedings and to make my comment today.
Okay, thank you. Any other comments? Questions? Anything else? So the idea is that we will work on sort of synthesizing all this information, getting a very rough draft of that may answer some of those questions about what is included. That can be the next working discussion issue for the December 22nd meeting. But the idea is that you'd have something to review over the next 2 weeks. Before
So Mark,
January 1st. Okay.
Sorry, earlier when we were talking about scheduling, you weren't sharing your screen. I don't know if you thought you were, but
Yeah.
could you just put that list up just so people can see the dates?
I will do that here. So let me get one. Good here. Okay. Here we have it. Do you all see that? So again, after you sort of mull over our discussion for this week and then get again a rough draft on December 22nd, what we'd be looking at is January 5th, starting to actually go into the detail of what does actually belong, what doesn't. The wordsmithing from Sheriff Heck too. Wordsmithing
You
from
should just
many.
write it.
And then that would give us really the opportunity then to have a good draft, something in a more finished state for January 12th. And then hopefully to finalize that report on January 19th. With the expectation there might be some hopefully non-major issues to revise. That's when it really comes down to the wordsmithing, and so that by January 26th, essentially, this group will approve the final report. So lots of work, during the holiday season, no matter what you're doing, rather than reading the night before Christmas or other holiday readings, you could be reading this and thinking up language as alternatives. But we will present you with something on December 26th to start with. or December 22nd. Hope I said that. Any questions? So again, I encourage you, December 22nd, that's when you can dive into the actual words and language. Okay. Seeing no other questions, comments, we can call this meeting to close. And we'll see you back next week.
Thanks, everyone.
Thank you.
Thank you.